Hello and good evening. This is attorney Brad Micklin. I'm the managing member of the McKinley-Law Group, which is a law firm concentrated in men's and fathers' rights in divorce, custody, and family law issues, with offices located in Nutley and Montclair, New Jersey. I'd like to welcome you to our monthly webinar series. This is the McKinley-Law Group's webinar, Equitable Distribution of Assets, What Men Should Know. We do this every last Thursday of a month, give or take. I will try to announce the date of the next one at the end of this, but it's also on my website, McKinleyLawGroup.com. So this is me, in case you haven't worked with me. My name is Brad Micklin. As I said, I'm the managing member of the McKinley Law Group. I am a member of the New Jersey State and Federal Bar Associations. I am licensed to appear both in state and federal courts. I began my law career as a judicial law clerk for the Honorable Eugene Austin. We did special civil litigation for Bergen County. I then moved on to Kessler & Associates, where I did complex commercial litigation for a couple of years. And then I opened my own office probably around 2000, 2001. I was originally a general practice attorney, which means I did a little bit of everything. Quickly learned you can't be good at everything, and you certainly can't be great at everything. So I decided to concentrate my practice into divorce, custody, and family law. And only recently did we move into men's and fathers' rights specifically as a concentration. Just for those interested, today is May 24th, 2018. So if you're watching this in the future, it's always possible that laws and the comments that I'm making have changed. But usually these webinars will have general basic information. It doesn't change too often, but still always good to update yourself in case it has. Here are some awards I've been fortunate to receive over time. They actually need to be updated now that I've been fortunate to receive many more. I don't put these here to impress you, but to impress upon you that I do know what I'm doing. I do care a great deal about my practice of law, my clients, and I want you to know that you can trust in the advice that I'm giving you. I often say that you don't know if you have a good lawyer until afterwards, which is far too late. So let's move on real quick. For those that may not know, we do offer a support group for men in divorce and custody issues. We usually do it the last Wednesday of every month, so it's usually the day before these webinars. It's at 7 to 8 o'clock. Time's not rigid, but I try to keep it within that time frame, and it's at my Nutley office. It's not usually going to be at the Montclair office unless there's a great demand for it. If there was a demand for it, I might even consider doing a separate one in that office. So if you're interested, please contact me. So let's talk about a little bit what we're going to cover today. First, let me give you an idea of how the webinar is going to work in case this is your first one. This is a 60-minute presentation. I do my best to keep it to that time frame. Sometimes it's less, sometimes it's more, but I do my best so that we get the information in and around the same time that I promise. You should know it's a one-way communication, so hopefully you can see my PowerPoint and hear my voice. If you can't, please make a comment. There's a chat panel that should be on the right side of your screen. Go either down to the chat or to the question section and just type something if you can't hear or see the presentation. I'll check periodically for that. You'll notice on the bottom of the chat panel it says there's a handout, so the PowerPoint that we're discussing is there for your reference if you want to print it out. Sometimes there'll be cases and statutes that are cited that may be good for your reference. This webinar will also be posted on my YouTube page, which is Brad Michael Micklin, and my firm's website, which is McKinleyLawGroup.com, usually a couple weeks after the webinar, so you can keep an eye out for it then also. I will take as much time as necessary to answer questions. I don't stop during the presentation to address them. So I would ask that if you have questions, when they come up for you, that you click onto that questions portion in your chat panel, type it in and send it to me so that it'll be there when we finish, and I'll take as much time as I need to address all of your questions thoroughly. So now let's talk about what we're actually going to cover here today. First, we're going to talk about what is equitable distribution, just the basic definition and main factors of it. Next, we'll talk about determining distribution of rights and obligations. Really, that's going to be about support obligations mostly. talk about how to protect the property that you have, different evaluations and different concerns that you need to focus on. We'll talk about a case, Slutsky versus Slutsky, talks about how business interests are handled in the divorce and family court matters. And then lastly, how to protect those business interests if you happen to have one, separate from being a W-2 wage earner. So let's talk quickly about equitable distribution. Equitable distribution is a term for the distribution of assets and debts. It is not equal distribution, although that is most commonly where it ends up being, absent the factors and issues that we were going to discuss in here. There's a presumption that all assets that are acquired, assets and debts that are acquired while you're married, are in fact marital assets and debts. There is a way to discuss non-marital and exempt assets, but generally they're going to be considered joint. The theory of marital enterprise says that the joint efforts of a married party contribute to the acquisition of the assets and the debts, regardless of whether or not there's a measurable contribution to the actual asset or the debt, and whether or not it's an equal contribution does not always make a difference. And that generally arose from the traditional circumstance where you had the husband that was the breadwinner and the wife who was a stay-at-home parent may not have actually acquired any assets or debts for that matter, but would share in it for the fact of raising the children and maintaining the house and caring for the husband. It's generally considered both spouses' efforts. There is no set calculation or formula, but I do generally start from 50% of marital assets. There are ways to change that, but that's where the presumption is going to begin in practice, at least. And then last, it's important to know there are no tax consequences generally to the transfer of assets and debts in a divorce, unless you want them to. The laws are currently changing. The tax laws are currently changing a great deal, and there might be circumstances where it might be more favorable to include taxable issues like capital gains and gift taxes in ways that historically would not have been so helpful. Now, we're not going to really touch on that because the tax reform is outside the scope of this, but it is very important to understand that that's significantly impacting equitable distribution and alimony going forward in divorce cases. So let's talk a little bit about how the court's going to start the equitable distribution analysis. It's really going to be a simple three-step process. First, they're going to establish what property is subject to distribution. There are going to be assets that are exempt, primarily gifts to one spouse, inheritances, certain types of injury lawsuits are all going to be considered exempt. So we need to determine what is and what is not subject to distribution. We need to figure out the value. Sometimes you need to figure out the value at acquisition as well as at the time of the divorce or the separation, or not separation, the division. And they're often competing values. One spouse will believe it's worth more or less than another. You may need to get more than one evaluation to determine the fair value. And then the court needs to figure out the best way to allocate between spouses. So it's not necessarily everything gets split in half and sold. It's not like a fire sale unless the parties want that or just absolutely can't come to their own agreement. But normally there's going to be considerations as to whether or not we can offset one asset against another. You're going to look at whether the tax consequences in the future are going to affect the distribution. And all these things we'll talk about when we get into the factors portion of the webinar also. So moving on to some of the more common factors that you're going to encounter in a court during equitable distribution discussions and decisions. First, it does not matter how you own the property. If you buy a house in just one person's name, or one's on the mortgage and one's on the deed, or it's not going to matter. If it was acquired during your marriage, it's a marital asset and it's a marital debt. So if you have a credit card that the other person didn't sign for and doesn't know about, that too is going to be marital, despite the lack of knowledge or being on the title. As I mentioned before, a very common way to handle distribution of assets and debts is by offsetting. So it looks like the tail end of this. This is about, you can offset one asset against another, so that there doesn't have to be distributions. One person may keep one full asset like the house, and another may keep one full asset like their retirement accounts as an offset. Sometimes you use the offsets to reduce your alimony obligation. You could give a larger distribution, for instance, of an asset and avoid paying alimony. This was favorable when before the tax reform, I should say. We're not really sure how things are going to play out now because alimony is not taxable on the federal level, but it is on the state level. So we're not sure exactly where the benefits of that kind of structure is going to fall. But if you're going to offset assets against one another, you need to be careful about what the basis was or the purchase price and the future tax consequences. So people get wrapped up in the belief that there's no tax consequence when you transfer by divorce, which is true. But later, when you go to liquidate or utilize these assets, there are going to be tax consequences. You need to contemplate that in your original distribution. For instance, just real quick, if you're waiving your interest in a house and keeping your pension or your 401k retirement account, that might equal out dollar for dollar. But when you can't liquidate your 401k or your IRA without significant tax consequence usually for a long period of time, where a house can be sold immediately, absent any capital gain issue. So you need to look at how that may affect the actual value. So it's not a dollar for dollar analysis. Judges can often order that you encumber these assets in order to pay for the appraisals and evaluations that I mentioned at the intro you may need. This is significant to know in advance in case you are interested in either keeping a piece of property, usually, which is where the most funding comes from, or if you believe your spouse wants to keep that property, you do or don't want that to happen. If you go into a case that's going to require a litigation fund, most commonly it's going to be a HELOC, which is going to encumber that asset. It's going to complicate your ability to keep it or to let the other person keep it. There's no double dipping, which means if there's an asset, normally means if there's an asset and an income that's produced from it, you don't count the asset in distribution and the income for alimony purposes. So if you're getting a pension and the pension provides X dollars per month, and then your spouse gets half of the pension in the divorce, then the income that you receive from the pension doesn't get counted into your alimony obligation. And any kind of structure similar to that, because it would just be unfair. Lastly, fault is not a consideration in equitable distribution. Truthfully, it's not a consideration really in anything in divorce, although you'll generally see a sort of catch-all, and I think you'll see it in equitable distribution factors later. There's generally a catch-all that allows a court to consider, quote, any other circumstances, but they rarely do, and fault is never. I've never seen fault as a consideration. Let me give you a caveat. Unless some action has significantly impacted the value of assets, like you dissipated assets because you were planning for a divorce, well, that's not necessarily fault to your divorce, but the action itself will affect the distribution of your assets. There's also issues in marital tort, far outside the scope of this. If you're interested in that, research a case called Tevis versus Tevis. That's T as in Tom, E as in Edward, V as in Victor, I, S as in Sam versus Tevis. It will give you a general explanation of what the marital tort's all about. I won't go into that today. So let's talk about distribution of property rights and obligations or support. What I'm going to do for the next few slides, instead of going step by step through all of the factors, because there's a ton of them, I'm going to list them all. I'm going to just put them all up on the screen. I'm going to tell you which ones are and are not considered, because there's a lot of them. The majority of them aren't considered in your standard average case, so it's good to know what you want to focus on when you do get into a divorce case and equitable distribution issues. So let me just, duration of marriage, age of the parties, the income brought to the marriage, standard of living, written agreements, economic circumstances. All right, so let's start with this page here first. Let me get my little pen up here. All right, so I'm going to do my best to write. All right, so duration of the marriage, that is always significant for equitable distribution and alimony. Just give me 1 second. I'm actually switching hands to see if my writing's going to be a little bit better over here. Age and physical health of the parties, not necessarily so much. Income and property brought to the marriage, no. Standard of living, yes. Written agreements, not so, unless you have a prenup or a postnup. If you do, then that's the agreement. There is no equitable distribution, so I'm going to say no to that. And economic circumstances, time of division, I wouldn't worry about that either. Duration of the marriage, age, yes. Let's put a circle around age. That's yes, only because retirement is often a big consideration. So out of this page, the important things to factor: duration of the marriage, age, and standard of living. All right. There are more factors, which is why I'm going to do it in this form. Earning capacity of each party, educational background, training, employment skills, work experience, absence from the job market, children responsibilities, education needed. So now let's be clear here. Okay, let me get my pen out. These are all part of this. So income and earning capacity of each party is one factor, and inside of the factor, these can be issues. So again, I'm going to go down education, they'll use that, training, employment skills, work experience, all significant. Length of absence for the market, sometimes that's hard to say, depends really on the type of career the person has or had. Not going to greatly impact equitable distribution. It's more going to be a concern for alimony. So let's just say no here. Custodial responsibilities for the children. I don't think so when it comes to distribution of assets and debts. Again, that's more of an alimony thing. And time necessary to get education, not going to be considered. The factors for equitable distribution and alimony are in a similar, if not identical, statute. So there's an overlap of issues, but for equitable distribution, I wouldn't be concerned with most of these at all. Let's move on to our next set of factors. Contribution to education of the other party during the marriage. Contribution to the acquisition of the assets. Tax consequences of the distribution. Present value. The need to occupy your own residence. That's in liability. The need for a trust fund, and here's the old, any other factors the court deems relevant. So going back here. Contribution to education and training. For equitable distribution purposes, that's no. Again, for alimony, it might be, but for our purposes, I would say don't worry about it. Contribution to acquisition of assets, no. Tax consequences of proposed distribution, maybe. It's going to depend on if there's a significant appreciation in assets during the course of the marriage, so that there's either capital gain issues or future tax consequences. That would be the only time you'd get tax consequences as a serious consideration is if you held the assets or you've had a long-term marriage, there's been significant appreciation. Present value of the property, absolutely, of course. The need of parents to occupy residence, no. Again, that's alimony more. Debts and liability, I think so. You know, you have to figure out, sometimes if somebody's taking more of the debt, they'll get more of the assets also, or they might get the business, but they take all the debt for, Need for creation of trust, no. That's only going to be in a high net worth case, and you'll know that long before it comes to issues of equitable distribution. Any other factor the courts deem relevant? I'm going to say no. Believe it or not, I've never seen the courts actually use that factor, that standard. That's really a catch-all. It gives courts a lot of power, but they generally don't use it, or I guess maybe even need it. So I'm sorry for going through that so quickly, but I figured if I did one by one, this would be a 3-hour webinar. So let's move on to what is and is not subject to equitable distribution. First, what is? all types of real property and personal property, houses, cars, bank accounts, intellectual property, all subject, at least the starting point is. We begin from the date of the marriage through the divorce complaint on average. That's what the statute says. Equitable distribution can begin at a date prior to, I guess technically after too, but also certainly prior to the divorce complaint if there's a reason to suggest it would be more appropriate or fair. A common example is if there's a restraining order, a final restraining order that physically separates the parties, but a divorce hasn't been filed, you can argue that that date should be the date for equitable distribution. Doesn't necessarily mean it's going to be, because the law presumes it should be the filing of a divorce complaint, but the law allows for some flexibility. So if there is a date that's more favorable for a reason in equitable distribution, you do have that ability to argue that and ask for those dates. As I mentioned before, inheritances and gifts are generally exempt. Certain kinds of personal injury lawsuits are also exempt generally. Premarital property is also generally exempt, other than if it was purchased in contemplation of your marriage, like you bought a house together a couple months before you got married, or you had a child and then you bought a house, then you got married, and or if you've commingled it. And this is a very important point because a lot of people do this. If you have premarital money, for instance, and you put it into a joint account, you are likely to lose it as a separate asset. It loses its separate identity and becomes a joint asset. And there is something, it's not showing up. Oh, sorry. There's a tacking on period. I don't know what happened to the picture. I think because I adjusted the slide. So tacking on for a period of cohabitation. That means if you cohabitated and you purchased assets or you had support issues long before you were married, some circumstances you can ask the court to consider that premarital cohabitation period for both alimony as well as for equitable distribution. The important part about that is if you're going to be seeking to have the court consider the cohabitation portion, that needs to be placed in the divorce complaint when you file it, which is important to know also, since this webinar is directed to men, if you happen to be on the other side and you're defending against a period of cohabitation to increase the length of the marriage, and it's not referenced in the divorce complaint, you need to raise that issue at the time of equitable distribution to preserve your rights. All right, so let's talk a little bit about some of the case law inside of equitable distribution. The first one, I'm not going to go in great depth about cases because generally they're only relevant for the main principle. Not going to give you too much of the facts of the case because you just have to know what they say because now the courts follow that. But this was a case in 2002 by the Appellate Division, which is the higher level than the trial court. They review the trial court's decision. It was addressing whether valuations should be made to account for minority interest. So like, for instance, if you have a 49% interest in a company, or even more importantly, you are an interest in like a family-owned business, something that doesn't have a lot of marketability or that you don't have a large share in. The distinction between fair value and fair market value, because the fair market value is what it's going to sell for. The fair value is what is the value of you retaining that interest through and after the divorce. And now they use the fair value issue or fair value, which is going to significantly impact the valuation, both for this and on another issue, which I don't think is part of this webinar, but about minority interests and minority discounts. So the family law's way of evaluating business interests is very skewed and outdated and generally leads to an inflated value. So if you have a business interest that you're going into with a divorce, you need to talk to somebody to understand in what circumstances that can be adjusted. But let's get back to this. So the holding was that it only applies, minority shareholder discounts only apply in extraordinary circumstances. Now what's important here is, in my experience, people generally think that this case and the law about equitable distribution says that there are no minority shareholder discounts. But that's not the case. This case specifically says absent extraordinary circumstances. And I don't believe there's a lot of cases that actually define what extraordinary circumstances are. But you have to remember that that does exist. So if you have a situation that factually differs from Brown versus Brown or the common case, you can argue successfully for a minority share discount. Most people will go in, most lawyers will go in just assuming that it doesn't exist because it's never happened in their practice. It's not common, but it does. Don't forget that extraordinary circumstance catch part. Here's just quickly was the breakdown of the facts. There was the husband had a minority share with his brother and mother. Again, like I mentioned, the family-owned business is your common example of a minority interest. So let's talk about how you protect these assets as a man. And I guess truthfully, it works as a woman too, but we still are in a situation where men still commonly make more than women do. Men still more commonly manage the finances of their homes than women do, in my experience. I'm not saying this is everybody, but just in case people complain to me later. All right, so let me try to get my pen out here so we can do some highlighting for you. First, do not commingle. I didn't mean to cross that out. Do not commingle. Let me just erase that. For those that are going to look at this later, I want you to be able to read it. All right, so we're going to lose the pen for here. Don't commingle. There's often a very large pull when you first get together to commingle, to put everything in joint accounts. You're in love and everything's great, and I'm not saying, well, don't commit to the relationship, but you went into this relationship with separate property knowing that, and that will help you guide it in decisions later, whether or not you're going to contribute to the purchase of a home, whether or not you need a pre or post-nuptial agreement. Commingling it just changes the foundation, the financial foundation for which your relationship began, and it's never a good move. It changes the expectations, and it affects the valuation later for divorce. So keep everything separate, which is number 2. I try will get my pen here. Pre and post nuptials. Prenuptial is obvious what that means. Postnuptial is like a prenuptial that you do after you get married. It's often called a reconciliation agreement. So if there's a contemplation of divorce, you can use this as a way to reconcile but resolve your financial differences both as your relationship goes forward and if you later return to divorce. So I'm a big fan of postnuptial agreements. The family court is not, because in many cases they find them to be coercive, sort of like a sign this or I'm leaving you. But I still think it's good to do, especially if you're going to try to reconcile. I think it's a perfect way to try to reconcile and really lay out your expectations going forward. Trust and estate planning, very important. It's not only in the documents themselves, but you may want to create trusts to hold different property so that whatever was premarital also retains that identity, that separate identity. Another way you can, if you want to retitle property, joint ownership with somebody other than your spouse, put it into a parent's name, a sibling's name, but it has to first of all, it should be for a legitimate reason, not necessarily just because you're looking to keep it from your spouse. That may cause you problems, both marital problems and legal equitable distribution problems. But there's nothing wrong with if you have a piece of property, for instance, that you inherited and you want it to leave to your mother or to your family because it's been in your family, you can put your family as a co-owner. So inside of the divorce, not only is part of the property owned by somebody else, so the value is decreased, but the intention of where this property was meant to go is also signified by the joint property. Lastly, keep records. If you have premarital assets, keep the statements, file them away, not just because you want to plan for your divorce in the beginning of your relationship. It's not what I'm suggesting. But there are going to be times when you're buying and selling assets, when you're investing in assets, and when you're getting divorced, that you need to know what the value of your assets are, what the tax consequences are. You're going to need it often for filing. Say, if you buy a house, you put a lot of money into renovations. You need these records. No reason to not keep them from the very beginning of your marriage. And it's going to help you if you get divorced. So let's talk about a couple special considerations that are quite common but not always there. Pensions, there's a couple kinds of pensions. First of all, there's a defined benefits contribution or defined benefits plan, a defined contribution plan, And then there's also federal plans that are uniquely different from those two plans. I'm not going to get into the specifics of those. But obviously, the thing to know about pension plans, first of all, is that you do not receive the other spouse's interest, or I mean your interest in the other spouse's plan until that person receives it. So generally that means retirement. You're only going to get what's called the coverture portion. That is the portion that was acquired while you were married. You normally will have to retain somebody to actually figure that out. It's not just a question of figuring out the value when you got married and the value when you get divorced, for pensions that is, because most retirement accounts, IRAs, 401ks, pensions, have shares. So each share changes in value over time. So just because it was only worth X dollars when you got married, the shares that you had when you got married may be much more valuable than the shares you have now. So there are companies that will actually figure out almost share by share the coverture portion. Real property will require a new deed and sometimes a refinance. That's important. You have to find out if there's going to be any kind of filing fees, realty transfer tax. Sometimes you can't refinance and somebody expects to be able to, so your agreement is that they're going to be buying out an interest. You need to have provisions that say what happens in the event that they cannot do so. You need to consider what appraisals you're going to need. Generally, they're going to be business, jewelry, lifestyle, and business are your most common for. You also want to know who's going to be paying for it. As I mentioned earlier, you want to avoid the court setting a litigation fund that's going to encumber assets. There might be better ways for you to do it. You might want to protect your assets from the court ordering that. Consideration of assets, the ability to earn and generating income. That is the asset's ability to generate income. So if you have a multi-unit real estate home and a retirement account of equal dollar value, it's not the same to just take one over the other, because the real estate is going to be an income producing asset and the retirement account is not, or at least may not be as equally. Active and passive income. I'm not going to go deep into the difference. Active and passive is where the asset changes in value based on efforts. Passive is where it changes based on market conditions. So you need to look at the asset. Is the income active or income passive, and is the asset active or passive? Again, I can't go deep into that here, but it's a very important distinction, especially when you're looking at exempt assets. Gains and losses, both currently as well as what you anticipate in the future. Again, it goes back to keeping a record of what the basis is and all your tax records. Valuation end date. So active assets, again, ones that you contribute to in your own efforts, like your home and a business, are generally valued at the date of the complaint, so that any change in value that happens afterwards is usually retained by the person who is contributing that effort and increasing that value. Passive assets are things like investment accounts and brokerage accounts that, again, change in value because of market change, not because of any efforts. They're valued at the time of either the sale or the distribution. It could be at the end of a divorce. So the reason is, if the market crashes during your divorce, there's no reason that one person should get the value based on the time that the divorce complaint was filed, because half of that, if not all of that's now gone, and it had nothing to do with them. Similarly, if a stock investment skyrockets and spikes, there's no reason to be denied that when the person who may own the stock didn't do anything to cause that. All right, so let's talk about the Slutsky versus Slutsky case. It's about business interest. This was a 2017 case, and the appellate division actually reversed and remanded this to the court, which means they said the trial court made the wrong decision. They sent it back for the judge to make a new decision. The issue was whether or not goodwill was a part of the husband's interest in a law practice. And just to give you some quick facts, the reason that was an issue, because it would seem implicit to those who know about business valuations and law firm interest, the lawyer in this case was a partner, but he wasn't I don't think he wasn't an equity partner, meaning he didn't own a share, or it was he was an equity partner, but only because he produced good quality work. He wasn't a rainmaker. He wasn't producing clients in business. So he had a different type of ownership interest than is common. So they had conflicting valuations. The judge is believed to have misunderstood the husband's conclusion, which led to some of the erroneous decisions. But basically, it recognized a nuisance value for determining the equity partnership, meaning there is still value. I'm sorry, I got to take a sip of my coffee. It sort of goes back to what I said earlier in this webinar about the minority interest, that there is still a value to business interests in all circumstances that go beyond and above just the dollar value of what the interest is, or what the business is. So how does New Jersey help men protect your business in a property division? First, as I keep saying, it's an equitable distribution state, not a community property state. And I keep saying that because everybody, lawyers and judges alike, go in thinking everything is 50-50. But by analogy, if you have an alimony issue, you might have heard about the 1/3 rule, where everybody goes in thinking alimony is 1/3 of the difference. So people go in thinking equitable distribution is 50-50, and that's an understandable, adequate starting point. But that doesn't mean it has to stay there. If you are going to be arguing for a distribution that is less than equal, then you need to consider all the factors that I outlined before, even the ones that I crossed out saying the courts don't consider. I wasn't saying, by the way, that they're not important. What I was saying when I did the cross and the circles are the ones that the courts generally don't consider. So if you have a claim that you want it to be more or less than 50%, you have to use those other factors, because each factor has a different amount of weight. So the ones that I circled are the ones that have the greatest weight. Doesn't mean you can't consider the other ones, and that's where you're going to get your offset or your unequal distribution. Make creative arguments for non-business owners to get less distribution. Not only using the factors, but again, using the cases where I said where they acknowledge that the minority interest issues and a lack of marketability issues do have discounts in certain exceptional circumstances. You need to find out what those are and utilize them. Don't go on the assumption, like everybody else is, that there aren't minority discounts, that equitable distribution is 50-50. Just don't do it. Again, remember that there's no double dipping, so you have to make sure that if there's an asset that's going to be creating income, that it's not going to be used against you in the future. Make sure it's clear. Some assets change. They might not be income producing now, but they might in the future. You need to consider that. Social Security, for instance, is an asset that you acquire later in life that is, often not even distributed. Something you might want to consider unless it's favorable to you not to. Deductions that are proper on a tax return may be added back in. That's something that you do want to consider. I try to stay away from giving a lot of tax advice in here, so this is something to make a note of. If you think there are deductions in the earlier ones that are carry forwards that you might be able to utilize, you should talk to your accountant for. I'm not going to go into a great amount here. And then considerations of debts to reduce equitable distribution of asset and tax consequences. Things kind of we talked about before. If there are debts, that either a debt against a property obviously is going to reduce the value of an asset. That commonly is going to be like a house and a mortgage. The tax consequences, like I said, again, you have capital gains in the future. You have the tax consequence of removing from retirement accounts with the penalties and interest. These need to be considerations carefully evaluated and determined. Meaning, don't just say, okay, well, I know when I take out my 401k, there's going to be penalties. You need to find out what the interest or the penalties and fees are going to be for dollar, so you know exactly how much is going to be taken out when you do. Don't just go and assume that it's 18% or whatever it is, but actually make sure that you know what it's going to be. All of these points here and the factors I circled before need to be considered thoroughly if you're going to be entering into significant equitable distribution claims, and most importantly, if you want to have less than a 50-50 or even more than 50-50 if you're looking to get a larger share. You need to use this information in its entirety. All right, so that pretty much concludes our webinar. I'm going to see if I have any questions. I don't see any. Always a little concerning, but hopefully that means I covered the information thoroughly for you. I don't see any comments that can't hear me, so it's not for that reason. But I'm going to hang out for another minute or so in case you do have any questions. Just post them on the screen like I mentioned before, and I'll do whatever I can to answer them fully for you. We're about 40 minutes in, so we got plenty of time. By the way, I just put up my phone number and my email in case you think of something after this that you want to ask me. Feel free to email me, mention that you attended the webinar so that I know exactly, to some extent, either who you are, like at least why you're contacting me, because I can't just answer random questions for anybody, but I'll certainly do my best to help anybody who's watching these webinars. All right, so I don't see any questions. I'm going to give it a 1, 2, 3, going once, going twice. All right, so I have to apologize because I don't know the name of the next topic of my webinar, but I can tell you at least the date. The next webinar is June 28, 2018. Again, that's Thursday night, 7 o'clock. I actually may be making them earlier at 6:30, so check my website, but it will also tell you the title of the next webinar. So thank you, have a good night, and I hope to sort of see you at my next webinar. Thank you.